Defending against a debt collector's motion for summary judgment while your motion to compel is pending. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. Suppose you're in a lawsuit against a debt collector. You serve discovery on them just like you should, and they either don't respond to it at all or file the usual pages and pages of bogus objections. You start the motion to compel process and eventually file a motion to compel, but meanwhile, they have filed the motion for summary judgment. What do? This scenario often happens, actually, as it is part of many debt collectors' playbook to object to all discovery and to file motions for summary judgment as soon as possible. The situation is difficult and very risky for a pro se defendant. Here's how you handle it in 6 steps. The first thing you always do when you get a motion for summary judgment, and notice that I'm going to call it motion for SJ, MSJ, motion for summary judgment. They're all the same, motion for summary judgment. So when you get a motion for summary judgment, the first thing that you always do is look at the rules controlling motions for summary judgment in your jurisdiction. You have to know how much time the rule gives you to respond. And you have to know what an MSJ must include and what it must look like and what evidence must be provided and how that's supposed to be introduced. Getting the rules is therefore your first step, even before reading their motion. Their motion will cite the rule. You can look it up and read it. You should. Second step, reading their motion. Duh, right? But you're reading it to see if their motion itself complies with the rules of civil procedure I just told you about, and if their evidence complies with the rules of evidence. And here's a clue. They usually don't. Keep that thought in your mind. Now, go back and check to see if your motion to compel will be heard in the normal course of things in time for you to get discovery before answering the MSJ. In other words, suppose you've requested a hearing and there is one next week. Then it doesn't matter if there's a motion for summary judgment. You can treat them as completely separate events. However, if you have not already filed your motion to compel, the answer to this one is going to be probably not. But if it is, you can treat the 2 motions as separate motions and follow through first on the motion to compel. But usually you won't be able to do this. So what then? Step 3, correlate the probable answers to your discovery to the issues presented in the MSJ. In other words, if you ask questions that would affect the, which would cast a light on the knowledge of any person who's testifying or on the credibility of the records, those things will obviously apply to the motion for summary judgment. They'll attack their evidence. So correlate the probable answers to the issues presented in the motion for summary judgment. Be very clear on how the answers will shed light on the issues raised by the motion for summary judgment, if they do at all. The motion for summary judgment says basically this: Judge, none of the important facts are in dispute. You can go ahead and rule on the case as a matter of law. We don't need a jury. To defeat their motion, you must show either that material facts, other than facts that could change the outcome of the case, are indeed in dispute, or that they prove the debt collector would not win. Look at every single thing your discovery asked for and see how it could produce material facts that would defeat the motion for summary judgment. Every single one. Step 4, write a motion for extension of time. This is a new thing. Write a motion for extension of time in which to answer the motion for summary judgment. You're asking the court to stay or to hold the motion for summary judgment until after you've had a chance to receive answers to your discovery. In that motion for extension of time, which I'm going to call MXD, you must demonstrate to the court how the answers to your discovery would tend to show a material dispute. In other words, in step 4, you are demonstrating in a written motion to the court what you worked out in step 3. The rules of civil procedure regarding motions for summary judgment will say something like, courts should stay proceedings to allow discovery of material facts. They'll say something like that in the very rule regarding motions for summary judgment. Point out that rule to the court in your motion for extension of time. And note, writing this motion involves a great deal of attention to detail. It's not an easy motion, but it is critical. Step 5. Do what it takes to get your motion for extension of time heard before the motion for summary judgment is going to be heard. Again, duh. Do you have to set it for argument? Ask for an expedited hearing? Do whatever it takes if you can. A lot of times, though, you can't. And this means that you'll be going into a hearing which may decide your motion for extension of time, your motion to compel, and their motion for summary judgment at the same time. What then? That seems pretty unfair, right? So what do you do then? If you're in that situation, you must not rely on winning your motion for extension of time or the motion to compel. You got to give it your best, try to win them, but you can't count on it. You have to go ahead and do the best you can of defending yourself against the motion for summary judgment. Remember how I told you that debt collectors almost never use legitimate, that is, admissible evidence in their motions for summary judgment? In step 6, you will write your opposition to the motion for summary judgment where you prove that in great detail. Follow the rules as to form. The rules of civil procedure say what you should do to answer a motion for summary judgment, and you have to follow those rules. You'll get the whole thing kicked out, your answer kicked out if you don't. At this stage, you defend the motion for summary judgment in the ways we always talk about defending motions for summary judgment. Take a look at our MSJ defense pack for samples and additional help. Actually filing your opposition, doing the very best you can, is a critical step. You must not skip this step, and you must do your best work. It isn't easy, but if you lose the MSJ, the other side gets a judgment against you, and you've lost. The case is over. So this defense is for all the marbles. Give it the best you've got. Of course, you can't take any of my videos as legal advice. They're educational, made by someone who used to practice a lot of this kind of law, and of course has been involved in it ever since for the last long time. Most people can represent themselves in debt cases because of the kind of law it is and the kind of business it involves. But you don't have to do it alone. If you are in fact representing yourself, you may want more help, and that's where our memberships and products come in. Please check us out. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com